little bit late, but better late than never. Greetings. Hello. Good morning. I know it's 4 o'clock. Well, where I am, it's 4 p.m. Where you are, I have no idea what time it is, although it probably is either 5, 6, 7, or much later or much earlier. Greetings to everybody. Hello to StreamYard. Again, my most loyal fan, Born Free Films, Chad, the one. Oh, how come you guys can't see me? You guys can't see me, can you? I think you're going to look at a brick wall until I figure out. Let's see. I'm glad I'm such a technical. There's a different choice. And there is another wonderful choice. There's a brick wall. There's that. Let's see if that one. Oh, did that just work? Oh, my goodness. Oh, look at that. Look at that. I actually somehow by accident, certainly by accident, figured out how to put me on this stupid screen. So anyway, as I was reading off the list, the 1-1, Zach, I like that. Jason Z, Toe, Zach, and Barbara, hello, the 1-1, middle ground. Jack, Barbara again, the 1-1, Gator Boy Lee, Donna, Renee, Rondell, Matthew. I just named everybody in the planet. So everybody, hope everybody's well. This is again a follow-up to the last live stream. Kind of this, I think the pace is picked up. So we will have, continuous probably news to report on or talking about things that are going on. And so this is since the last live stream, which I think is like 2 days ago or 3 days ago. So this is and this is information that I've garnered from my dealings with whomever. It'll become evident. Before I start, as I rattle a bunch of papers off, which I'm sure is very pleasant, I wanted to say hello to Shohei Atani. I really did not know this till recently, but he's a big fan of GTII and follows my channel very carefully. So hello, Shohei. And also, I wanted to say hello to all those counsel or parties that are involved in litigation who enjoy my channel. Greetings to all of you. Please like, subscribe, and share. And if you want to discuss at a deposition, feel free to talk about it at a deposition also. Apparently, in a conversation I recently had, there was a good amount of time, I think, in 2024, where as opposed to planning on how to rectify their accounting problems, the principals spent more time trying to figure out how to go after me, which I found kind of humorous, but I guess, it's borne out. I found that whole scenario kind of funny in a way. So before I get started, of course, I wanted to throw out a couple things. And maybe you can kind of explain these things. A couple of these things are just things I just don't understand. And, whatever. Not the first, not the last. But if you're a vegetarian, can you go to Macau? Please help me understand that. And also, I think next month, and I don't know, this is a little personal and kind of in-depth, really. But, as you get to a certain age, you have to have a colonoscopy where they kind of take a peek into you and they check out your, check you out. And I've had that done before and whatever. And depending on how it goes, the repeat time is short or long. They also can do it where they send a scope down and they check your esophagus. And sometimes they'll do that kind of routine because you kind of age over time, things change, whatever. So I was thinking about this. I'm having this done on the 13th of next month, and I'll be out, so it's quick and whatever, painless. But it's funny to me that the process when they stick the tube down your throat is called an endoscopy. And shouldn't the colonoscopy actually be called the endoscopy, if you know what I'm saying? Anyway, things that troubled me. I also kind of found out, and I find this guy very funny. I spilled a spot remover on my dog, and now he's gone. Could somebody help me find him? Another question I had, and again, maybe some of you can help me on this. What's another word for thesaurus? And last but not least, whenever I think of the past, it just brings back memories. Anyway, maybe we'll have a couple on the way out. There's been a lot of discussion, and it's going to be in depth more so as I go, but I'll throw it out just kind of whatever. Compensation of the receiver for GTII. So in the last report, he was pretty vociferous. I thought it was pretty, it was interesting, the report. And again, I can have different views about the receiver. I could think he's doing a good job. I also could not like things he's done. I also have to commend Dylan Siciliano, who's the receiver's counsel. His and I communication has improved a lot. I think it's helpful, so I have to give him props for that. I don't give props to his client, the receiver, but I give props to Dylan. I think he's been, reaching out, been more communicative, and I appreciate that, and I hope that continues on. But I don't find his again, I have split views about the receiver. I can think he's doing certain things well, and I could say other things he's not. And part of it is I was kind of put off by the last report. There was a lot of words wasted about the receiver's compensation. So in anticipation of, I guess he's going to request compensation, he kind of like was throwing it out because he's heard probably me and others question his compensation. Apparently, and this is what Dylan mentioned to me, I think he mentioned that Forster from AIversity wants, this is what Dylan told me, and again, I don't know what anybody said because I wasn't there, but that Forster doesn't want the receiver to get any shares. I don't know if that's true or not, and I don't know, so I don't know. But that's what Dylan Siciliano told me. I wasn't a party to that, but my view is a little different. So my view is that when the compensation package, and part of his pitch was that plaintiffs, so that group of plaintiffs that filed the original action in Nevada, which was me and a bunch of other people, when that was filed, that there was an agreement on the compensation of the receiver. Now, again, when that's a little bit misleading because that was done by counsel. There wasn't a disclosure, and there's nothing wrong with it, by the way, but there wasn't a disclosure to the 250 plaintiffs saying you agree to this or not. So when you say the plaintiffs agreed to it, it's not really being accurate. The other part, of course, is what was known, and this is me. What was known as there was like 65 million shares that had been issued like at the last minute under the dark lights, and half of those were canceled, so it left like 32 million or 30 million shares. That's what we thought were the disputed shares, and we didn't call them disputed because there was no name, or I think the council has now called them disputed, so we didn't have a name for it, but that's what we're talking about. So even though we weren't involved in the deal, and even though we didn't elect the compensation of the receiver, we were thinking that he might get 10% of those 30 million shares. That would be 3 million shares. We didn't think he would be attempting to secure 10% of 170 million shares and would become, or try to become, the number one shareholder. And if we would have known that, and if the court would have known that, I don't think they would have approved that compensation package. Of course, the receiver should be compensated for his efforts, but he's not acted individually and by himself. He's had counsel that's done a myriad of work. And, to be honest, because he's boasting, I'm referring to the receiver, he's boasting in this report about, wouldn't happen without, and I'm paraphrasing, wouldn't happen without him. Well, just to be honest, this wouldn't happen without me, and I'm not seeking 17 million shares So let's keep this all in a proper perspective, Mr. Receiver. You're not the superstar here, and this is not getting done just because of you. And you could have elected not to do it. And so we're here. And so again, I think fair compensation to the receiver is fine, but I don't think he should be a whore, and he shouldn't be the number one shareholder. And he should deal with it. And he hasn't dealt with, when he can dispose of shares, the order, et cetera, all stuff neglected, by the way. But the bottom line is in Nevada, and I'm no Nevada attorney, like Markowitz, and we'll talk about him. But there's a standard, and the standard is reasonable. So the compensation has to be reasonable. And I don't think it's reasonable myself. And I'm not making any money here. So not going to make a difference to me, but I think definitionally it's not reasonable, and he shouldn't be going after 17 million shares. And if he has a different idea, he should put it out there like everything else that he's elected not to put out there. That's my criticism of that. So I assume that, and again, we've talked about shareholders getting involved, and here's a particular, and again, if you disagree with me, and just don't listen to what I'm saying. If you agree with me, my premise, and I know there's been people asking in the past about getting attorneys and having an attorney participate. So if and when the next application for fees comes, so there'll be some kind of application, there have been in the past, where the fees of the receiver have to be approved by the court. If there's a time when a group of shareholders wants to hire counsel in Nevada to assert an objection, I would think that would be a proper method of challenging that. And if it's not challenged at some point in time, then it's kind of waived. I've tried to been upfront about it. I was upfront with Dylan about it, that I think it's unreasonable. It's not in a reasonable sum. And again, that was not known, and the shareholders weren't involved. And but that's my position. So I'll keep you aware the next time there's an application for fees and shares. And again, if some of you want to get together and hire a Nevada attorney because you don't agree with the distribution of shares, then do it, and have that counsel assert an objection. If you think the receiver should get more or is entitled to what he is, then don't. If you hire counsel and you want whoever counsel to speak with me, then have them reach out to me, and I'm happy to give them whatever information I have. But that's the issue with the receiver's compensation. He addressed it a lot in the 5th interim report. It seemed like it was his writing kind of flavor. It was very defensive. And again, part of the problem is his lack of transparency. And again, I'm not saying he's not doing a good job in some respects, but transparency is not one of those respects. And he takes the criticism personally, like I'm after him. I'm after the interest of the shareholders. And I was thinking about this today. Do you think the guys at Trento, do you remember that live stream when the guy was literally sweating like it was flop sweat city? JR and I interest throughout has been the interest of shareholders, period. And so I can't help it if the way the receiver acts is not in a manner that I think's in the best interest in the shareholders, or that the shareholders deserve more information. So that's the gulf that I have with the receiver. He takes it that somehow I'm working or have ulterior motives. He just doesn't get it. So I can't help him. And that's kind of the reason why I've tried to communicate more with Dylan, so that in our communication, he can kind of get the flavor that, notwithstanding my style, my intention is for the shareholders' interest. And I don't give a shit about the receiver, to be honest, in any way. Except that when he accomplishes positive things, I'll disclose them. So few things. Rabbari's deposition is going to be apparently December 3rd in Las Vegas. It's as to the shares that he's claiming. I mentioned earlier that in the discussion of the date and the discussion of the receiver's actions I had with Dylan, I mentioned that I think the reason why the shares were canceled, I was giving those guys so much crap in early 24 and mid 24. I was sending them constant emails, questioning their tactics, and they kept on misrepresenting the truth, in my opinion. And as a result, I think when Rabbari saw that, this is just my opinion, when Rabbari saw that, that's one of the reasons he did the cancellation of the shares, because there was a lot of pressure on them. That's long before the receiver was even born, or was a gleam in his father's eyes, as we say. So Rabbari's deposition is going to be December 3rd. And again, part of the discussion I had with Dylan Siciliano, and I get a glee out of it. We were just talking about it, that Rabbari, apparently Kathy Griffin, and our favorite Mr. Reichman were engaged in discussions about me, as opposed to doing what they, ripping off the company more or whatever else they were doing. I don't know what they were doing, by the way. The ripping off the company I base upon what the receiver's reports state and all the filings. That's and it appears that all that is directed more at the prior board, Reichman and etc. And Rabbari was came in much later, and he probably had a much more difficult position. Realistically, he came in, he probably learned a lot of stuff. And I'm speculating, I don't really know, but he probably learned a lot of stuff, and it was difficult for him. And he probably found out it was difficult to control Reichman and whatever, but I'm just guessing because I wasn't there, and who knows what happened. But we know what the receiver claims, and that is that. So that's happening December 3rd. In the interim, there was a stipulation in order, and I mentioned it, between Reichman's counsel and the receiver's counsel, extending the date for the claims, just as to David Reichman, until December 31st, 2025. Other than the ones we've mentioned before, and there were very few, that claim date is expired. I think it was September 15th. They're extending it, and I'll just read the paragraph so you'll kind of get it, and then I'll talk about it a little bit. Paragraph 5 says, the receiver and Reichman are in discussions concerning a potential settlement of claims and related releases, which will be subject to this court's approval. So I think I mentioned before, I was speculating because I saw the documents, and they mentioned the claims, and then they mentioned the ones who disputed shares, and then the ones who had kind of gone away. And I didn't see Reichman's name, and I knew there was a prior mediation. And I think I kind of, although I've not got a 100% confirmation, but it seems like settlement negotiations are ongoing and deep, involving Reichman. And when I saw that, just to kind of put things in perspective, because I also, let me just kind of continue this way. So I saw that, and I'm fine with that, by the way. So you just have to be realistic. As much, and you will see, because I sent an email, and I'll read you the email so you'll get it. I understand. As distasteful as I find any cordial settlement with David Reichman, in reality, because of costs of litigation, because of time, because of just circumstances, because you could lose, because there could be bankruptcies, all kinds of things, there is value in negotiating resolutions without necessarily going through trial, even if you're dealing with scumbags. And maybe sometimes, especially dealing with scumbags. Because if you're dealing with somebody with deep pockets, like if you were going to sue Warren Buffett, it wouldn't be tough to figure you could collect, and you might spend a lot more time and energy in doing that. But if you're dealing with scumbags, and they might file BK, or they don't have any money, or that's been pledged, whatever, then you might want to do it. So that'd be one reason. Secondarily, if resolving with one opened the door to resolving with many, that might be a reason why you would do it. So in this case, and I'm just speculating, although again, my speculation, you'll see that it's more than speculation, I think. So they might think that if we settle with David, then we're going to settle with Justine, we'll get settled with a bunch of other people, and everybody's going to roll, because if David rolls, then what are they going to say? Everybody's going to roll. And does that have value? I mean, is it value to save a bunch of money, to get everything done, to expedite things? Of course it does. So I understand why this date was extended. I don't believe or trust David Reichman. I don't. But I know he has a lot to lose here, and I know he doesn't have a lot of money or liquidity. And to the extent that this goes much farther, he's going to be spending a lot of money, and he can't pay. I don't think he can pay his legal fees. Honestly, if he can't pay his legal fees, then there's no way to contest this, and the result's going to be terrible. So I think it's in his best interest to negotiate some resolution. And I think I don't believe the receiver is going to negotiate only a resolution with David Reichman. I think it will have to include a lot more people, entities for it to go forward. And I think that would be really good. To the extent we could resolve the share issues quickly, like within the next 90 days, I think that'd be fantastic. It would increase the the liquidity of all shareholders, even nobody can trade. So at first blush, it's annoying that they're trying to do a deal with Reichman. On second blush, then there's benefit, and I see the benefit, and I've done plenty of litigation, obviously settled lots of cases with scumbags just because the practicalities are the practicalities. And we'll go from there. So what I did, though, just because I was interested, and I was kind of, I read something else, and we're going to talk about that in a second. I read so two of the prior attorneys for GTII filed, and I think I talked about this, basically an objection to the share freeze that would apply to everybody, but they filed an objection. And since then, there was a opposition filed and a motion to disqualify those attorneys. So and those attorneys assisted Reichman and everybody else, according to the receiver, to do whatever they claim. And you'll hear the language that the receiver accuses, especially Markowitz, of is pretty brutal. And Markowitz is counseled, like in-house general counsel for GTII. Reichman had if it's your counsel, you probably know what your counsel's doing. So as a result, and I'm thinking about it, and I knew that there was negotiations were ongoing, and I see quotes from people on X who are pissed off at Reichman and want to see him go to prison. Like I want to see him go to prison also, but I want to see that the shareholders make out. So I'd prefer that the shareholders make out, then Reichman go to prison. So I'm okay with that order. Or if he doesn't end up in prison, as long as the shareholders make out, I'm okay with that also. But I know that others may not be. So what I did is I sent an email over to Dylan yesterday, and I'll read it. Good afternoon. I'm aware, and I said it wasn't just to Dylan, it was to William Knoll, it was to Margarita Elias, and it was to Little JR too. He was on here too. Good afternoon. I'm aware that I'm not, and I try to be direct and honest. I think I was, but whatever. I'm aware that I'm not privy to many relevant communications, am not familiar with ongoing strategies, etc. I also understand the cost and complexities of litigation, parentheses. I've made suggestions for actions that have not been implemented, like suing JR, not RJR, but that stands for Justine Reichman, I believe, in California, etc., and then close parentheses. And that settlement with one party may lead to settlement with others, etc. Despite that, giving any kind of sweetheart deal to David Reichman, I put DR, that's my initials for him, would make me and many other shareholders ill. That is before reading your persuasively drafted opposition to the Oliphant birdcage quality filing. And I'm referring to the motion or whatever to stop the freeze that the prior GTII attorney Oliphant filed, which I characterize as birdcage quality filing. In that opposition, I'm referring to Dylan's opposition. You basically accuse Markowitz and Oliphant of engaging in criminal activity connected only to and with the assistance of DR, David Reichman. That you could assist David Reichman personally in any material way appears incongruent with the conduct you have accused him of, parentheses, notwithstanding the practicality. So what I'm saying is basically, if you're going to give him a sweetheart deal, you've basically claimed he's a criminal scumbag. So I don't see you giving him a sweetheart deal and being a criminal scumbag to be consistent. Per my review of X, many have much stronger feelings about DR than I and would like to see him locked away and other versions based on your reporting. Before I discuss the issue publicly, I wanted to give you an opportunity to provide your further rationale. If you wish to call me, please feel free to contact me at my number, Richard. And he did. So I reached out to him and I laid that out and we talked. And again, this conversation, he couldn't be specific, although we didn't even talk about him not being specific. But it was a conversation kind of around the topics. And we talked about the practicalities of settling with Reichman, and he honestly wanted to get my opinion based upon these comments about what I think would be acceptable in a settlement. And so, and again, this is from my experience as a lawyer, what I think would be a reasonable settlement, under the circumstances, if it generates a lot of additional benefit, like resolution with a bunch of other shareholders, get back a bunch of shares, all other kind of benefits without having to expend, hundreds of thousands of dollars in extra legal fees and wait, which is our biggest issue, waiting, because it's already taken a long time. I bitch about the audit. That's taken an inordinate amount of time. So we had a discussion about, Dylan and I last night, about what I thought was a acceptable level of a deal because I believe to get the deal done, they're going to have to give up something. So notwithstanding whatever the circumstances are, to get it done now, there has to be some consideration return, not just like, we're not going to go after you. There has to be some benefit. That's my view, and that's based upon my experience. So what I said was, if Reichman had like 80 million shares, I would think 10% would be a reasonable settlement, and maybe 5% would be great. So that would be in the area of, if you had 80 million shares, that would be the area of 4 to 8 million shares. And even though that's an obnoxious number, to get a deal done, I think that's a practical number. And by Dylan's response, I don't think that my guesstimate is far off from the negotiations or what they're negotiating. That was my impression. He didn't react like it was crazy or that it was far off, whatever. Maybe he's a great actor, perhaps. But that's kind of what. And he also wanted to get a feel for what the crowd would think. And again, I told him that there's a lot of people that are pissed that don't want to give him anything, and I understand that. I do. But to get it over with, if it gives you the right deal to make a huge load of progress in one fell swoop, then I think there's practicalities, and I'd be okay with it if it was a small amount like I indicated. And I don't know if Reichman's bullshitting and this is just a delay tactic, which I suspect, but I'm hoping not. But if it can get us to the end by this quarter, and that's kind of what I'm thinking, if they ask for December 31st, if we can get basically all those share issues done by the end of this quarter, I think it'd be great. So that's my view, and I'll keep you apprised. We're going to know because it's going to be presented to a court. So if and when there is a deal, we will know. If and when there's not a deal, we will know that also. And of course, I will keep you apprised. Now, additionally, there's other issues that are involved. There's still the tax issues I mentioned in the report, and I don't know what's going to happen about that. And then you will see there's, I think, and again, I'm no criminal specialist, but there's also, I think, issues that are going to rise their head with some of the attorneys that participated. So what I'm going to next is there was a motion to disqualify that was filed by Dylan Siciliano against the attorney, Scott Oliphant. Scott Oliphant is representing Warren Markowitz, who used to be in-house counsel at GTII, and CY. Just think about this. What kind of dick uses this kind of name? CYA Holdings LLC. Cover your ass. ESK, that's an abbreviation for an attorney. Holdings. That to me is like a dick, but just my point. So the Oliphant, and I went over it, at least in part. This particular motion to disqualify is 100 pages long, so I'm just giving you the highlights. If you'd like to read it the entirety yourself, most of it is exhibits, but you can certainly look at it. And yeah, let me give you like a little heads up. So if you read legal documents, you can see it's kind of in sections, and there's a bunch about the law. But if you want to get an understanding of the facts, what's a good idea is look for the declarations, and there will be declarations, and read through the declarations, because that kind of gives you a more factual, non-legal background, and also sometimes will explain the documents to you. And so if you get a 100-page document and you don't know where to go, just read the declarations to start off with. It'll kind of center you and give you a good summary, because otherwise, you get lost. Now, I honestly, for me, I probably spent 5 minutes on it. I got what I wanted. I kind of knew what the issues were. I don't need to know, it verbatim, but I got enough of it. So here's the basic argument. And these guys are trying to unfreeze those disputed shares for everybody. And the basic position is Oliphant, who represented apparently GTII as an outside counsel on a couple matters because he's a Nevada attorney, was hired by Markowitz, who lives in Nevada, I guess, is involved with Nevada companies, but is not a Nevada attorney, and was I think it said in one of the filings, was turned down so you could apply pro hoc vice. You could apply as an outside attorney to participate in the case, and apparently that was denied at some point in time. But Oliphant apparently worked on behalf of GTI, Markowitz in-house counsel. They're involved in share issuances, etc. And this issue involves those very shares. So, and Oliphant was an insider, and Markowitz is an insider. So they have confidential information, and they're trying to use that confidential information. I think that's the point of this argument, against GTII, the company they represented, and that they got access to that confidential information in their position of confidence. And on that basis, and that was a quick summary, on that basis, they're being disqualified. According to the papers, Mr. Oliphant, who's a 25-year attorney in Nevada, served as GTII counsel from 2022 to 2024, didn't seem like he was like a big fan of our judge, because he said he wasn't subject to the court, even though he's in Nevada, even though he practices law in Nevada. He said he wasn't subject to the court's order or jurisdiction, and refused to recognize the receiver's authority. So it's interesting, because now he may be appearing before the judge. Now there's a hearing on this motion for disqualify. I think it was January 15th, at 75 days. But there was also a request for order shortening time, which means, in essence, you want to get the date earlier. But I don't know if that January date was the earlier date. It may be like, the courts are so crowded that the earliest date might have been March. But there's a hearing in January. So it's going to be interesting to me to see if by January, remember we talked about this, and we'll see if it plays out. Be interesting to see if Mr. Oliphant is going to be the one arguing this motion or this opposition in court with this judge after he basically, disrespected the judge's authority. So I wouldn't be surprised if somehow they drop their motion, or if suddenly, instead of Mr. Oliphant appearing, that they hire some other counsel mysteriously to appear. Because I wouldn't want to go in front of the judge that I just called out with anything. And part of the argument here about the conflict is there are a bunch of restricted shares of stock. What apparently these guys would do, and they're called Rule 144 opinions letters, so Oliphant would do a letter for Markowitz would do a letter for Oliphant so they could sell their shares. And obviously Markowitz assisted, according to these documents, with a lot of other misconduct. So that's going to be heard in January. And at the same time, an opposition was filed. Excuse me, that's really rude. But thank you. An opposition was filed, and it basically attacked Markowitz. And it said, and I'm reading from the opposition and the documents. I don't think there's a hearing date yet on this particular motion. And again, it's subject to that motion to disqualify because the party filing this motion is Oliphant, and now there's a motion to disqualify him. But it talks about Markowitz in part that his relationship with GTII was volatile because he wasn't getting paid. He had a bunch of unpaid fees. He then resolved it. Who knows how it was resolved? And then he was doing things apparently for Reichman and for GTII and for others. And he apparently, I'm just reading the topical sentences, and you'll kind of get what the allegations are. And this is from the filings by Dylan. Markowitz and Internet Capital, which is one of the companies that was set up apparently. Oh, you'll just listen to it. Markowitz used Internet Capital to launder stock proceeds to Reichman and Markowitz. That tells you a little bit. Now, if they're accusing them of criminal laundering, that's a serious accusation. Not a criminal lawyer. I don't know if that was intended, but that's a pretty strong statement. Then they reference that there was and we've talked about this, and I don't know all the moving parts. So there was some deal where 10 million shares were transferred to Markowitz Internet Capital Company, and then $2 million came in for those 10 million shares. I don't think that reflected the actual value of the shares. That's $2 million, according to this document, came in from Tommy Wang. And of that 2 million, apparently 1.8 was diverted to Reichman, and 200,000 was, because they use this term in here, skimmed to Markowitz. I think I read it here it is. Mr. Markowitz, so this is on page 6 of 19. Mr. Markowitz further admits to skimming the $200,000 and remaining intentionally ignorant of the nature of the transaction. So this is kind of like a private, off-the-books transaction in which some shares apparently, and I don't know what happened to those shares, but some shares go in, but $2 million comes in. Reichman gets 1.8, and Markowitz takes 200,000. It's suggested that's not kosher or above board, especially with the title being that they're laundering proceeds. The next heading, and I'm looking at page 7 of 19. And by the way, Markowitz is going to be deposed, as is his Oliphant. And I don't know if those guys are going to testify, if they're going to be actually testify at the depositions. I didn't know if they're going to take the fifth. I can't imagine that the SEC is not looking into them based upon what's stated in these documents. I mean, we were speculating. We know the SEC is involved. But I can't imagine that these guys are going to escape. I don't know why the bar, in Nevada hasn't even been involved. If that's what they're doing, if they're assisting, if what the receiver says is correct, they're assisting in misconduct that's harming shareholders. I don't know why shareholders aren't going to the bar and complaining in Nevada to have them stop that conduct, if it is as the receiver says. So the next holding is Markowitz used CYA, that cover your ass LLC I mentioned, to launder funds to Reichman. And that included, I guess, they got 1 million shares from Roy Lester on March 23rd, 2023, involving the estate of Arthur Schwartz. The agreement notes that the sale price of these shares was 20 cents per share. The closing price of GTI shares on that date was $2.28. Or in other words, Cover Your Ass acquired the shares at 1/20th the market price. The next thing that's asserted here, page 7 of 19 in this filing, Mr. Markowitz's statement that there is no direct or indirect involvement of or with GTII is at best perjury. This is what the Receivers Council is accusing Markowitz of. I have no idea of the truth of any of these statements. I think I reached out to Markowitz a couple times in the early period. I might have spoken to him once very briefly. I don't think he was cooperative in the least. But other than that, I had no communication with him. But it's amazing that the Receivers and the Receivers Council is calling out perjury. That's a pretty strong statement. And apparently there's a memorandum also from Markowitz dated May 31st, 2023, that provides the proceeds from Cover Your Ass's shares are to be distributed to Markowitz, Kathy Griffin, David Reichman, and Sal Loria. I've heard the name before, but I don't think I've ever spoken to Mr. Loria. Like I said, Reichman, I've communicated but not spoken to. Markowitz, I've spoken to. Kathy Griffin, that's an interesting one, by the way. And I mentioned this to Dylan last night. So at one point, and I'd spoken to JR about this. One point in time in 2024, I was giving them a hard time. And Kathy Griffin inadvertently sends me, I think it's inadvertent, sends me an email that she was sending, I think, to Reichman and Rabbari. Basically, I don't know if it went to Rabbari. I know it went to Reichman. It might have gone to somebody else. And basically says, Hoffman is roasting you. Can you do something about it? Eventually, there was a lawsuit, and then they dismissed the lawsuit. But it was funny because she sent it to me. So, the level of incompetence at that place is astonishing. I then sent her, I disposed of it and sent her an email to say, you probably shouldn't send me these type of emails. But that tells you kind of, again, the level of competency of that type of management. So they were going to get, there's handwritten notes and a bunch of other weird things that are claimed that Markowitz is involved with. And again, I don't know the truth of any of it. It'll be interesting to see what happens. Then there's discussion about Oliphant. He claimed to be entitled to shares based upon an engagement agreement or his agreement. Markowitz apparently hired him. And in here, page 9 and 19, I'm reading what the Receivers Council says. Mr. Oliphant has a fraudulent engagement agreement with GTII. And I guess the reason why they claim it was fraudulent is because it's backdated. And I guess they have a way of tracking that it was backdated. And if you recall, there was like some agreement in the transfer of power of CEO away from David Reichman that was also backdated. That was, so it appears that that's a tactic. And just so we're clear, it's not a lawful practice to backdate legal documents. They again reference that the 10 million shares that were transferred. They somehow connect that. If you recall, I mentioned there was a claim involving a bunch of companies and Mr. Wang for $43 million. And here on page 3 of 11, paragraph 9, somehow the receiver kind of is tying that to those 10 million shares. I don't really know how he's tying it, but that's what he's referencing in here. He's referencing the $40 million claim, and then on July 1, 2022, 10 million GTII shares were transferred to the company's profit sharing plan. And somehow he's connecting that. I don't know if that's an argument they're going to be making with regard to that specific claim. And, then it refers to those wire transfers. So Mr. Wang obviously did give $2 million, but and I don't know what Reichman did with the money. And I don't know what Markowitz did with the money. So then it says, I'm just going to read this just because it's interesting. This is what the Receivers Council is saying. In his own email to my counsel and me, Mr. Markowitz explains what I believe to be tortious and probably illegal conduct. That's what the receiver is claiming. So continuing on, and I'm just reading like the headlines here. Warren Markowitz is a central figure in the conspiracy being investigated by the receivers. The receiver believes there's some kind of conspiracy and that Markowitz is a key figure in that. So that's being investigated. And I don't believe it's I can't only believe it's the receiver. I got to believe it's the SEC. I got to believe it's the IRS. I got to believe it's maybe DOJ. Now, probably not DOJ because I don't think the current DOJ gives a rat's tush about what's happening. They're as inept and disinterested in retail shareholders as the prior guys. So I hold no hope for them. But perhaps the SEC, just because they can make a name for themselves, they could bust a bunch of lawyers and other scumbags. Maybe they will have an interest. And I'm sure the IRS, where apparently nobody paid any taxes on these shares, apparently no proper forms were issued, apparently somebody's going to have a big liability. And I told you when Benintendo's deposition occurred, which I attended, and the issue of potential tax liability for the entirety owed by GTII, Benintendo almost passed out in his chair. So continuing on, furthermore, Markowitz concocted schemes to issue unknown sums of money to GTII officers and directors, and specifically David Reichman. Another accusation leveled by the Receivers Council. And then they go on to say finally that they kind of mutually, to get their stock unrestricted, Markowitz would issue a 144 Rule 144 opinion letter for Oliphant, and Oliphant would do the same for Markowitz and others, apparently. At least that's what the allegations are. So that's the opposition to the motion, or that's a very short version of the opposition to the motion by Oliphant on behalf of Markowitz and Cover Your Ass, along with all the other parties, because they would be impacted too, to unfreeze all the disputed shares. I thought the original motion, which I discussed in our last live stream, was poorly drafted. I thought the motion to disqualify puts those guys in a very difficult position, and the opposition, would you want to risk committing perjury in your opposition based upon what's alleged there? I think that's a difficult position. And I'd be interested to see when the depositions occur, if they take the fifth or if they testify, or if they give up their shares in lieu of making their claims. So it'll be interesting to see. So we kind of went over a bunch of topics today. Deposition that's of Mr. Rabbari. We talked about a motion to disqualify. We talked about the opposition. We talked about settlement negotiations and what would be a reasonable settlement. We talked about the receiver's compensation, and we talked about how it was reflected in the last report. We talked about, to the extent anybody feels similarly about the receiver's compensation not being reasonable, that there's nothing holding them from hiring a Nevada counsel to challenge compensation when it comes up. I also discussed the fact that I have different positions on different aspects of the receiver. Some of it, I think he's done a great job, and some, like being transparent about his, trying to justify his compensation, about him being the only one responsible for where we are today, in a good way, by the way, not in a bad way. Yeah, I don't buy it. So we talked about all that, and I'm sure, because we're in a flow now because of the litigation, because of all what's going on, because of the claims process. I think we'll be seeing a lot more paperwork, and we'll be commenting on it as we go, and we'll get a lot more information and kind of background as we go also. If you pull these documents and you read them and you have questions or different perspective, feel free to post them, state them, do whatever you want. Let everybody give a different perspective and a different view of the world. So that, and for everybody who hung out, I appreciate your patience and your ability to withstand those amazing jokes, and just to end on an appropriate way. And again, I appreciate everybody out there for hanging in. And if you have questions when this is posted, please put them on there. If I can answer them, I will. Sometimes I can't answer them. Not that I don't know the answer, but there may be a reason why I don't answer. So I know it might be frustrating, but sometimes maybe you'll assert a question, maybe somebody else will answer it, or I will respond. So I appreciate that. Do any of you think it's wrong that only one company makes monopoly? And this is a joke. In light of the accident that happened yesterday in Kentucky, the plane crash, I'm not going to say it. I'm going to hold off on it. So I drive somebody asked me about that. Are you concerned about your health markers? And my response is, I drive way too fast to worry about cholesterol. And last but not least, kind of related to the last one, when I die, I'm leaving my body to science fiction. Anyway, to all of you out there, have a great evening. Be well. Take care. If you have questions, reach out, and we'll talk soon, I'm sure. Take care. Bye-bye.